Hey everyone, and welcome to this super comprehensive explainer. Look, I know that staring down the entire South African court structure can feel completely overwhelming at first. It's like a giant puzzle, right? But honestly, don't worry, we are going to build a totally foolproof, grounded mental map together for your introductory law exam. We're covering every single concept, every single jurisdictional limit, and yes, all those tricky Latin terms. We are literally leaving nothing behind today. By the time we wrap this up, you're going to have exactly what you need to absolutely crush your exam. So, let's start climbing that ladder of justice.
All right, to get our brains organized, here's our agenda. 1. Jurisdiction and the courts. 2. The magistrates' courts. 3. The High Court. 4. The highest courts. 5. Special courts. And 6. Alternative dispute resolution. Okay, let's jump right into Section 1, Jurisdiction and the courts, laying the foundation. So before we can even look at specific courts, we've got to understand Sections 165 and 166 of the Constitution. These are absolutely crucial because they officially vest judicial authority in our court system. But how do we actually know which court gets which case? Well, we have to translate some legalese here. Think of jurisdiction as a court's ultimate official permission slip to hear a matter. A court is only competent to hear a case if it checks 3 specific boxes. First, the type of case. Criminal jurisdiction is based on the offense and the possible sentence, while civil depends entirely on the claim amount. Second, geography. Say a car accident happens in Pretoria, or the defendant actually lives in Pretoria, meaning they are domiciled there, then the Pretoria court has geographical jurisdiction. And third, what stage is the case at? Is it a case of first instance, an appeal, or a review? Speaking of stages, this brings us to a really critical Latin term you just have to know for your exam: court a quo. Simply put, this is the court of first instance, where a case is heard for the very first time. Think of it as the starting line of the whole legal process. A fantastic memory hook for your exams is that a quo literally translates to from which. It's the lower court from which a case originates before it potentially climbs higher up the ladder.
But what if you're totally unhappy with the decision from that court a quo? Well, you absolutely need to know the difference between an appeal and a review. You lodge an appeal if you genuinely believe the judge made a mistake on the actual merits or facts of the case. Basically, they erred in their decision and you want a higher court to fix the answer. On the flip side, you take a case on review if the actual procedure itself was irregular or unfair. For instance, if the magistrate was clearly biased against you or flat out refused to let your key witness testify. That's an unfair procedure, so you review it. So just remember, appeal equals an incorrect decision, review equals an unfair procedure.
Moving right along to Section 2, the magistrates' courts, the first rung. Stepping onto the very first rung of our ladder of justice, we find the magistrates' courts. Now listen up, because here is a massive exam tip. Magistrates' courts strictly act as courts of first instance. They do not, ever, hear appeals. They're split into 2 levels, and you absolutely must anchor these numbers in your mind. First, district courts. They handle less serious offenses like minor theft or drunken driving, and they cap out at a maximum sentence of 3 years in prison or a fine of $120,000. For civil claims, it has to be strictly less than $200,000. Then you have regional courts. These handle a much wider district and are way more powerful. Criminally, they can handle major crimes like rape and murder, but note this for the exam: they can never hear cases of treason. Their limits are much higher, up to 15 years in prison or our $600,000 fine. And for civil matters, they handle claims falling perfectly between $200,000 and $400,000.
Let's keep climbing. Section 3. The High Court. Stepping up.
At the provincial level, we arrive at the High Court. Picture walking into one of these grand buildings. Each High Court has jurisdiction within its own specific province. A highly testable fact here is that the head of the High Court is called the Judge President. And unlike the magistrates' courts we just talked about, the High Court is super versatile. It acts as a court of first instance for very serious matters, but it also acts as a court of appeal or review for cases coming up from those lower courts.
For the High Court's jurisdiction, it's all about the limits. If a civil claim is more than $400,000, it bypasses the magistrates entirely and jumps straight to the High Court. If a criminal case is so severe it requires more than 15 years imprisonment or a fine over $600,000, boom, it goes here. And here is a literal golden nugget for your exam. Only the High Court has exclusive jurisdiction over matters concerning a person's status. Think about major life changes, getting divorced, being declared officially insolvent, or matters of mental capacity. Only the High Court can touch the status of a person.
All right, we're in the big leagues now. Section 4, the highest courts, the absolute peak of justice. We're entering the absolute peak of the judicial hierarchy, the place where the ultimate legal precedents are set. Let's take a quick mental trip to Bloemfontein, to the Supreme Court of Appeal, commonly known as the SCA. Now, remember how the High Court is headed by a judge-president? The SCA is simply headed by the president of the court. Notice that term quorum on here? That just refers to the minimum number of judges required to officially hear a case. For the SCA, that usually means a quorum of 5 judges of appeal. For the exam, you need to tattoo this on your brain. The SCA is never a court of first instance. I mean, the word appeal is literally right there in its name. It only hears appeals from the High Court. But when it does hear a case, it wields immense power. It has jurisdiction over the entire country, it can impose absolutely any sentence, make any order, and its decisions legally bind all lower courts.
And finally, the ultimate crown jewel of our entire legal system, located right in Johannesburg, the Constitutional Court. Contrast this with the other courts for a second. The person heading up the Constitutional Court holds the distinguished title of Chief Justice.
You definitely have to memorize that the Constitutional Court requires a higher quorum of 8 judges, and its decisions firmly bind all other courts in the country. It's primarily the highest court of appeal for constitutional matters, but, and this is a big but, it also acts as a court of first instance in 2 very specific ways you need to know. First, Section 167(4) gives it exclusive jurisdiction over highly sensitive matters, like, say, deciding if the president failed to fulfill a constitutional obligation. Second, Section 1676 allows for something called direct access. This means in incredibly urgent, high-stakes matters where justice simply cannot wait for you to slowly climb the whole ladder, you can actually bypass the lower courts and knock directly on the Constitutional Court's door.
Shifting gears a bit, let's look at Section 5, Special Courts, dealing with niche justice.
So, our justice system has these specialized branches designed for very niche disputes. Why? So the main courts don't get completely clogged up. You'll see a variety of them here: the Children's Court, Maintenance Court, Labor Court, Equality Court. But honestly, the most highly tested number on this entire list is the small claims court limit. It caps out at exactly $20,000. This is absolutely perfect for a minor dispute. Say you're trying to recover an $15,000 unpaid loan from a friend, or someone owes you for spilling coffee on your laptop. You don't need expensive lawyers here. You represent yourself to get fast, highly accessible justice.
And finally, Section 6, Alternative Dispute Resolution, or basically staying out of court completely.
So, what if we want to avoid that formal ladder of justice entirely? Let's be real. Formal litigation can sometimes be a total nightmare. It is wildly expensive to hire advocates, cases can easily drag on for years, the actual courts might be hours away from where you live, the complex proceedings completely confuse most people, and that rigid win-lose structure, it often leaves everyone involved feeling a bit defeated. This is exactly why Alternative Dispute Resolution, or ADR, is so incredibly vital.
To solve all those headaches, we have a sliding scale of ADR. Think of it moving from the least formal to the most formal, entirely based on third-party involvement. First up is negotiation. This is just the 2 parties communicating directly to find a win-win. 0% third-party involvement. Next is mediation. This is basically negotiation, but with the help of a neutral third party. Let's call it 50% third-party involvement. The mediator doesn't decide the outcome for you, they just expertly guide the parties. Finally, arbitration. This is a private mini-court with 100% third-party decision-making. The arbitrator listens to both sides and hands down a final, binding decision. But remember, linking back to what we learned earlier, you cannot use arbitration for criminal matters or matters of status, like a divorce.
Okay, I'm going to leave you with this final, exciting pop quiz question to test everything we've covered today. If a massive, complex corporate contract goes completely sour, but both companies want to keep the dirty details totally secret from the public, and they absolutely need a guaranteed, final, binding decision, which ADR method should they choose? Think carefully about what we just covered regarding third-party control and binding outcomes. If you guessed arbitration, you hit the nail on the head. Trust the incredible mental map we've built together today. You are so ready for this. Good luck on your law exam.